Hello, good evening. Am I audible? Can the technical team please confirm?
Yes, ma'am.
Yeah, thank you.
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this international symposium has been incepted to herald law to promote peace. The first International Symposium on Law and Peace, which is organized by MIT WPU School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of the law. The ISLP strives to provide a common platform to legal professionals, youth, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for a digitally dynamic and complex society. The main mission of arranging the Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience, sensitizing budding legal professionals as conflict resolution ambassadors, to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, the youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with the law. Let's make the best out of this golden opportunity. Welcome to the first International Symposium on Law and Peace.
Good evening to one and all. Very soon we will be starting the first session of ISLP. I request all the others to join as early as possible because at 5:30 p.m. IST sharp, we'll be starting the first session of the International Symposium on Law and Peace.
Advocate Jayant Bhatt ji, namaskar. I see the sir is there.
Good evening, madam. I hope you can
Good
see me.
evening. Namaskar. How are you?
I'm good. How are you?
I'm good. Great. We had a very good inaugural session today morning, 10:30. We'll start sharp on time.
Very well.
We're just waiting for other speakers to join.
Sure.
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is envisioned to be the harbinger of hope that will lead human beings towards harmony. Law indeed is the means to attain the ultimate goal of peace through amicable dispute settlement, and therefore this international symposium has been incepted to herald law to promote peace. The first International Symposium on Law and Peace, which is organized by MIT WPU School of Law, aims to become one of the brightest beacons to herald peace and harmony through the lens of the law. The ISLP strives to provide a common platform to legal professionals, youth, policy planners, thinkers, and global society at large, where they can come together for dialogue, open discussions, deliberations, and can use the platform to recommend measures to address conflict resolution through peace-building processes, to promote the culture of peace and harmony for a digitally dynamic and complex society. The main mission of arranging the Symposium on Law and Peace is to promote peace and harmony in global society through lawmaking processes and policy decisions by imbibing the principles of justice, equity, and good conscience, sensitizing budding legal professionals as conflict resolution ambassadors, to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, the youth, society, and industry about legal dimensions and peace perspectives. Law is there for us when we are there with the law. Let's make the best out of this golden opportunity. Welcome to the first International Symposium on Law and Peace.
Welcome, Dr. Mehdat Fajlali ji. Namaste. Dean ma'am.
Namaskar. Welcome to MIT World Peace University, sir. I think you are facing some connectivity, audio issue, in fact. Pranima, you need to help.
Yeah.
Do you hear?
Yeah, you are audible now. Welcome to MIT World Peace
Thank you.
University.
Good evening, sir.
Good evening, Chaudhary sir. Good evening, Girisan sir.
Good evening,
Good
madam.
evening, Dr. Chaudhary Girishan sir. A moderator of the session, Advocate Jan Bhatt, is also there. Good evening. We have 4 more minutes to go. We'll start sharp on time.
So dear participants, I think we are coming very close to starting the first session. We're just away by a couple of minutes more, and at 5:30 p.m. sharp, we begin with session 1 of the first ISLP. Namaste, good evening, good morning, good afternoon to this August gathering and all the participants joining from different parts of the world. I, Dr. Pronima Bagchi, welcome you on behalf of Dr. Vishwanath Karad, MIT World Peace University School of Law, to the first International Symposium on Law and Peace on the theme Role of law to promote the culture of peace. As per the tradition of MIT World Peace University, we would like to begin the very first session of the first ISLP with the World Peace Prayer. I request everyone to join your hands, close your eyes, and pray to the Divine Almighty. I also request my technical team to kindly relay the World Peace Prayer.
Om Namo Jiyadya Veda Pratipadya Jaya Jaya Swasamvedya Atmarupa Devatuti Ganeshu Sakalartha Mati Prakashu Mane Nuruttidasu Avadhari Bodhi Gurur Brahma Gurur Vishnu Gurur Devo Maheshwara Guru Sakshat Parabrahma Tasmai Sri Gurave Namaha Purnamada Purnamidam Purnat Purnamudachyate Purnasya Purnamadaya Purnameva Vasishyate Om Shanti Shanti Shanti.
Thank you so much for your wholehearted participation. Dear delegates, we experienced an overwhelming participation today in the inaugural session of the first International Symposium on Law and Peace, organized by MIT World Peace University in association with the Pune District Bar Association. Advocate Hemant Batra in the inaugural observed, and I quote, "We must accept the issue of pending cases with honesty and magnanimity," unquote. The future of the justice delivery mechanisms across the world rides on the success of the e-courts. Ladies and gentlemen, I once again welcome all of you to the first plenary session of ISLP, which is on the theme, E-Courts, the Future. We are about to witness an interesting deliberation by all the dignitaries present on the online days. Dear participants, it is my privilege to welcome the moderator of this session, Mr. Jayant Bhatt, Advocate, New Delhi, Bharat. Mr. Jayant Bhatt is an independent legal practitioner who is an alumnus of National University of Singapore and the New York University, USA, from where he completed his master's. He has also worked in the prestigious law firm Clyde & Company LLP in Dubai for 2 years before moving back to India. Currently, he is a senior panel counsel for Government of India in the Honorable High Court of Delhi. He has a keen interest in mentoring young minds and has been a prolific speaker at various platforms. Welcome, sir.
Thank you so much.
My friends, it's my honor and privilege to welcome Kenneth Wincon from Law Offices of Kenneth and Wincon, Texas, United States. Sir graduated with a Juris Doctorate degree from Southern Methodist University School of Law in 1972 and began his legal practice in 1986. Attorney Wincon is licensed to practice law in the state of Texas numerous federal courts and state and federal agencies, and has experienced practicing in immigration law, criminal law, family law, personal injury law, international law, aviation law, so on and so forth. He has accumulated extensive criminal trial work experience over the last 46 years and has supervised the practice of personal injury law for the last 30 years. Well, he has spent time in Scandinavia, Europe, and the Orient working on international legal matters, business and corporate negotiations, and government issues. His international law experience includes representation of an Australian manufacturing firm establishing in Hong Kong involving legal matters with the Chinese government, as well as clients from Vietnam, Mexico, Korea, India, and numerous European countries. Sir, I'm sure we all are looking forward to hear from you, and thank you so much for being here on this platform. We are deeply honored to have with us Dr. Nasir Thijani, who is a Deputy Director General and Head of the Lagos campus of the Nigerian Law School. He attended the University of Lagos, where he obtained his Bachelor of Laws honors in 1985. He was later admitted to the Nigerian bar in 1986. Thereafter, he proceeded to obtain his Master of Laws from the University of Lagos in 1992. He also holds a PhD in law. Dr. Thijani is a fellow of the Chartered Institute of Arbitrators, UK, and a notary public for Nigeria. Dr. Thijani started his professional career in 1986 as a legal advisor to the Erokudun local government area headquarters. In 1998, he developed his passion for teaching while being employed as a part-time lecturer at the University of Calabar. Thereafter, in 2001, he was employed by the Council of Legal Education as a lecturer at the Nigerian Law School, where he works till date. We are indeed honored to have you, sir. Thank you so much. Ladies and gentlemen, I feel extremely glad to welcome Mr. U.C. Kanu from the Department of Litigation, Nigerian Law School, Lagos campus, Nigeria. Sir is a senior lecturer at the Nigerian Law School campus. He is a solicitor and advocate of the Supreme Court of Nigeria. He teaches criminal litigation, civil litigation, professional ethics and skills at the Nigerian Law School, where he's a specialist consultant in criminal law. He was a resource person to United Nations Office for Drugs and Crimes for the implementation of Administration of Criminal Justice Act and Sentencing Guidelines in Nigeria 2017. It is indeed an honor to have you, sir. Thank you so much. Well, now I feel extremely elated to welcome Dr. Mehrdad Fajlale, the General Secretary in Turkey, World Organization for Peace in Turkey, as well as an Associate Professor. Sir is a President of Turkish Inventors and Innovators Association. Sir is an academician of European Academy of Sciences and was selected as 2020 Inventor of the Year by this organization. Welcome, sir. Friends, it is indeed our honor and privilege to have such a distinguished panel today. And I now request Professor Anuradha Parasar, Dean of School of Law, Faculty of Liberal Arts, School of Visual Arts, and School of Performing Arts to kindly address the gathering. Ma'am, over to you.
Thanks, Dr. Bakshi. Namaskar to one and all. Respected dignitaries on the dais, distinguished honorable members of legal fraternity who are attending this meeting online, as well as those who are present here, respected Honorable Chief Justice, Honorable Justice of Supreme Court, High Courts, Honorable Sitting Judges, Honorable Former Judges, distinguished Senior Advocates, members of Bar Association, advocates, lawyers, fellow colleagues, participants, members from media and press, faculty, staff, and my dear students. A very good evening to one and all as per Indian Standard Time. It's evening 5:30 p.m. in India, so please accept my heartfelt greetings as per respective time zones. Welcome one and all to this technical session on e-courts, the future of the first International Symposium on Law and Peace at Dr. Vishwanath Karad, MIT World Peace University, Pune, Bharat. And MIT World Peace University, in association with Pune District Bar Association, is organizing this first international symposium on law and peace from December 14 to 17, 2021 on the theme Role of Law to Promote the Culture of Peace. And today morning, there was a very grand inaugural session for this prestigious conference. At the outset, I wish to express gratitude and thanks to Honorable Revered Professor Dr. Vishwanath D. Karad, sir, President, MIT WPU. We express gratitude to MIT WPU's International Symposium on Law and Peace patrons and organizing chairs, Honorable Executive President Shri Rahul V. Karad, and to Dr. Lalit Bhasinji. We also express gratitude to MIT World Peace University's School of Law Advisory Board members, Shri Nani Krupani, Justice Dilip Karnik, Advocate Makarand Adkar, Advocate Satish Mansinde, Advocate Anand Desai, Advocate Aniket Nikam, Advocate Ravi Kini, Advocate Rajendra Shirodkar, Advocate Mohan Pungalia, Advocate Mrunalini Deshmukh, Professor Dr. K.L. Bhatia, Professor Dr. Dilip Uke, Advocate Sudhir Vakure, Advocate Anita Agarwal, Advocate Aditya Pratap, Advocate Komal Joshi, Advocate Kapil Khair, and Advocate Satish Malik. I also take this opportunity to welcome and express gratitude to all distinguished speakers of ISLP technical session, all the legal luminaries who are gracing right now the virtual dais of International Symposium on Law and Peace. And we keenly look forward to your address on e-court, the future. Thank you. Vande Mataram. Jai Hind.
Thank you. Thank you so much, ma'am, for sharing these insights with all of us. It's now time to request Dr. Bharat Chaudhary, Dean Academics at MIT World Peace University, to kindly propose the welcome address. Sir, over to you.
Thank you, Dr. Bakche. Good evening, good afternoon, good morning. Welcome for International Symposium on Law and Peace on Role of Law to Promote Peace. On behalf of the UNESCO Chair, Revered Professor Dr. Vishwanath D. Karad, sir, Founder President and Chief Patron, MICE MIT Group Pune, and President, MIT World Peace University Pune, Bharat. And on behalf of Shri Rahul V. Karad, sir, Managing Trustee, MICE MIT Group, and Executive President, MIT World Peace University Pune, Bharat. And on behalf of all trustees of MICE MIT, on behalf of Dr. Ravi Kumar Chitnis, Vice Chancellor, MIT World Peace University, faculty, staff, students, warm welcome to all of you for this session on e-courts, the future. In last 3 decades, we have seen an explosive growth in the use of information and communication technologies, that is ICT technologies. It has given a birth to the internet in 90s. And now the internet has become an integral part of everybody's lives and profession. This session on e-courts, the future, would be playing a crucial role by highlighting the roles of ICT in the courts and judiciary. We have already seen how the courts have used ICT very effectively during the pandemic in the last 2 years. For this session, we have Advocate Jayant Bhatt, who is senior panel member for Government of India, New Delhi, Bharat, as moderator for this session. Hearty welcome, Mr. Bhatt, for your distinguished presence here and looking forward to listen your views. Today we have a galaxy of speakers. We have Dr. Mehrdad Forale, General Secretary in Turkey, World Organization for Peace. Welcome, sir, for your distinguished presence. We have Mr. Kenneth Wincon, Law Offices of Kenneth G. Woncom, Texas, United States. Welcome, sir, for your eminent participation for this session. We have also Dr. Nasir Thijani, Deputy Director General and Head of Campus, Nigerian Law School, Lagos Campus. Welcome, sir, for your eminent participation for this particular session. We have UC Kanu, Department of Litigation, Nigerian Law School, Lagos Campus. Welcome, sir, for your eminent participation for this particular session. Warm welcome for your distinguished presence here. I hope that the audience will enjoy listening the thoughts of our eminent speaker. Once again, welcome all of you for this session. Thank you.
Thank you. Thank you so much, sir. Ladies and gentlemen, before we proceed, I would like to request all the panelists to kindly turn on their cameras and wear a beautiful smile so that we can capture this special moment that we are experiencing of heralding law to promote peace. Well, I think in this new normal, post-pandemic or be the pandemic, this is how we capture the moments, the special moments. So I request my technical team to please take a group photograph of the very first plenary session of the first International Symposium on Law and Peace. This is indeed a very special moment. Thank you. Thank you so much. Dear delegates, we are now heading towards the first session. This conference, being organized under the guidance and stewardship of Honorable Executive President Shri Rahul V. Karad, is envisaged to initiate dialogue between lawyers, judges, policymakers, jurists, academicians, youth, and industry experts. Sir, EP sir, thank you so much for being the backbone of our support, and we are really honored to have your presence. We hope to go ahead very strongly with your words of wisdom and motivation. I now kindly request my technical team to relay a short film on the theme of this session. Over to my technical team.
For decades, the judiciary across the globe has faced numerous obstacles while working. And the recent takedown of pandemic e-courts has proved to be a blessing in disguise. The immense growth of the technology and information sector in the country has paved a path for e-courts to flourish. Judges and staff seem to find online courtrooms convenient and advantageous and are opting for the same extensively. Speedy trials and a healthy courtroom environment have been a dream of many, and online courts are reducing these hassles swiftly. Though a complete shift to e-courts might be a threat to the traditional systems, it might lead to the modern era of judiciary. This session will discuss an insight on the importance of the future of judiciary and the impact of adopting the e-court system.
Thank you so much, and we all are indeed ready to embark on this intellectual journey. I would now like to formally hand over the session to our moderator, Advocate Jayant Bhatt, Advocate Senior Panel Member for Government of India, New Delhi, Bharat. Sir, over to you.
Thank you. Thank you so much, ma'am, for such a warm welcome, and my greetings to all the panelists, all the students, and the staff here who have formulated this wonderful symposium spread over 3 days along with Pune Bar Association. Welcome to all the international dignitaries from the world over. And before I start, I must also congratulate the technical team, which made all the lawyers smile, just before the session. So I think that's a wonderful step towards the peace process, because with all the lawyers together, the last thing that one can think of is a peace at such a wonderful platform. Having said that, I think e-courts is something we have all embraced, if have not envisaged, especially because of the pandemic. But these last 2 years of COVID-19, especially 2020 and 2021, have taught all of us, be it lawyers, be it judges, be it litigants, be it a common man who is fighting the cause of justice, that we can perhaps embrace technology and can go forward with that. Without taking much of your time, let me open the dais and start throwing questions at our wonderful dignitaries who have joined us from different corners of the world. And let me take common questions and take them one by one to all the speakers. Yes, Dr. Bakshi.
Yeah. Very sorry to interrupt, sir. A very kind request. If you can take the mic closer so that we can hear you more clearly.
Right. I'll try to be as loud as possible.
Thank you so much, sir. Thanks a lot.
Right. Whenever you think the voice is dimming down, please feel free to interject. We want all the participants to benefit from this session. Dr. Fojlali has joined us from Turkey, Dr. Kanu and Dr. Thijani from Nigeria, and Mr. Incon from United States of America. A very warm welcome to all of you from India. Though we are enjoying a cold December evening, but we hope that with these warm discussion, it warms the cockles of our heart and help us brainstorm very critical issues regarding the e-courts, which we all have been grappling with in the last 2 to 3 years of the pandemic, which has grappled the world. So with that, let me put first question to this panel. I would like to know individually from different perspective of different countries as to how the courts in Turkey, United States and Nigeria have embraced e-courts, and what are the possible challenges that you see is created with the adoption of the virtual e-courts. Let me start by focusing on Dr. Fojlali. If you can perhaps start answering this question, and then I'll go to the other speakers as well.
Thank you. I welcome your presence, dear participants, and thanks to organizers of this conference for inviting me to speak among you. I am attending in this conference as a Secretary General of World Organizations for Peace in Turkey. In addition, I'm President of Turkish Inventors and Innovators Network Association and Office of World Inventors Association, IFIA, from Switzerland in Geneva. On behalf of the President of organization, Mr. Carlos Peralta, I convey the message of peace and friendship to all of you. The World Organization for Peace is an institution that its function will be to preserve human life on the planet and outside of it. The worldwide organization will conform to the guideline of United Nations, which is the running parent organization that together with the countries which are members determines and proposes destinies of all our humanity. I will speak briefly about the role of technology in court and ultimately making peace. Technology has invaded our professional and personal lives. The courts have not been immune to this invasion, but rather are actively participating by maintaining courts records electronically, enabling or even requiring electronic filing of pleading and orders, and building high-tech courtrooms for evidence presentation. Not all of this change have occurred due to proactive decision to modernize. Indeed, some have come about due to limitation on the old way of doing business, and other because of convenience. There are examples of current processes and procedures in criminal and family court case that portend the future use of technology in the courts, namely internet video streaming application that enable remote participation in hearings and distance communication between parties, and software programs that help to minimize conflict that often occur between parents during their efforts to comply with custody and visitation orders. Video arraignments and bond hearing are typically in many state courts, and number of courts are using internet video streaming applications such as Skype, WebEx, and FaceTime to allow far away and parents to visit them, with their children and participate in some course hearing. Additionally, courts in nearly all states have sanctioned the use of software programs that manage the details of shared parenting issue and parental visitation, share the calendar of children, store information about the children and expense associated with their care and custody, and document communication between both the parents and the children. Litigation will be is it a problem? Is there a problem?
No, we can hear you, Dr. Fojlali. We can hear you.
Okay. The rate at which litigants seek geolocation data will increase in civil and criminal case. This information will be available from cell phones, tablet, cameras, GPS, and other location system and new technology products that have yet to be invented. We can expect an onslaught of new variable computer products devices, such as Google Glass and others that are still only runners, including eyeglass, mounted computer system, head-mounted computers, Apple iWatch, and other smartwatch devices. In criminal case, both prosecutors and defense counsels will be speaking GPS, cell site, and geolocation data. Law enforcement will seek the data to prove that the defendant was or could have been at the same time as crime at the time of its communication, or to disprove the defendant's alibi defense that he have somewhere else. Criminal defense counsel will be seeking similar information about the prosecution's witness to disprove that eye, ear, witness were at the location where they claim to have seen or heard that which prosecutor claims. In addition, I predict that some member of future societies will attempt to record their entire day with their personal variable devices. Witnesses and litigants falling into the category will be prime subject of the data search. I think I can safely offer two additional predictions in the category. First, Google Glass and similar variable computer devices will be banned in nearly every courthouse. Also, there will be steady reduction in the number of vehicle collection cases filed each year because of the increased prevalence of computer guides cars and vehicle avoidance system. Moreover, most public streets will have video cameras connected to centralized face recognition program and data banks that will capture image of the event and identify the participants, leaving no doubt regarding to identify participation and the party at fault, and adding vehicle license plate recognition capability to the mix. The vehicle owners will be identified even if the fact of driver is not recognized by attempted recognition systems. Thank you to attend.
Thank you so much, Dr. Fojlali. Now let me take the limelight to Dr. Kanu and take his opinion on the challenges and on the solution of the e-court system and the future that it holds for all of us.
Good. I guess it's good afternoon there. It's good morning here. It's a pleasure being with you. I would like to address some of the issues that we are having in the United States because they're somewhat different than in some other places. It's because of our systems. We have a system which is our primary law is the constitutional law of the United States, which has some very, very important requirements. And one of them is that we have jury trials, and we have a right to a jury trial. For felonies, generally it's 12 people. For misdemeanors, for smaller offenses, it's 6 people. And you have to get those people together, and because of COVID, that's been very, very difficult. The difficulty with the e-system is that we've been able to put very few trials together because with the jury system, one, we don't get the juries, they don't show up. They're afraid of COVID. In many cases, when they do, if you're using an e-system, you have to separate everyone. When you do that, you have major issues with controlling what they're doing and the rules that we have, because we have very, very strict rules about what people are able to, what information they're able to access. If they're able to, and they obviously can't be, in a criminal case, the defendant can't be sitting with the complainant. And in the same room with the defendant, you can't have the defendant's family, but you can't tell, you can't see who's there. Very often that's a huge problem for the courts. Every plaintiff's attorney or defense attorney in a civil case can demand a jury trial. That has slowed down our system tremendously. We have a backlog. We really can't match it because we can't get the juries to show up, but we're mandated by our law to do that. We don't really know quite how to handle this yet. We also have an even more complex problem in that every state has its own constitution. That constitution usually requires also jury trials. How to manage that, how to do it. Each state has got their own rules that is normally promulgated by their Supreme Court about how they handle these trials. And the e-court system, we have to have it. There's no choice. With COVID, we just can't have the open trials that we normally had. But we also don't have the ability to judge witnesses properly. In the e-court system, you can't observe their demeanor. We have to have the initial part of the trial where we actually ask questions of each juror. You need to observe each one and their body language in order to determine, in the criminal case, whether they are telling the truth or they're not. And the jury makes that determination. They can't see what everyone else is doing. Now, we have the way to avoid that is to have trials before the court. It has to be by agreement of the parties. And very often that's not possible to do. The attorneys make a decision, normally a proper one, that they can't get a fair hearing out of the judge by himself, that they want to have all of the members of the jury in order to protect the rights of the individual. The technical ways to do this just aren't developed yet in our system to make it really work very well. And the only solution to this would appear to be the end of COVID, and that doesn't seem to be coming very quickly. We have, with this new strain coming, that's going to create even more fear in the populace and make it more difficult to get juries. Now, where it does work is with evidence exchange, with the e-filings. E-filing has been a tremendous help. Speeds things up, it's accurate. The difficulty we have with e-filing is in some of the smaller towns and counties, they don't have the capability, the understanding of how to be able to do that. And they're just learning. Even though we've had it for a while, it's still somewhat in its infancy. But that is an absolutely marvelous development that is going to help the system forever. I think that's with us. That's not, we're not going to lose that. In international tribunals, it seems to be the e-court system works pretty well and will work better. It's going to take a lot more experience, but it will happen. But with our system in the United States, it is really not understood how we're going to be able to get where we need to be. Another problem is getting people who are by themselves, if we have multiple defendants, be represented by their attorneys and have their attorneys where they need to be with those people, because we do have trials, we have even mass trials sometimes. All death penalty cases, they have to be decided by a jury. Not an option. A person cannot plead guilty and get a death penalty. He has a right to a trial, and he's not allowed to plead himself. And part of that's because some people have mental issues, they have sentencing issues that need to be considered, and if they plead guilty, that this isn't heard by the tribunal, it's not heard by the jurors, and you don't get a fair sentence. The credibility of the witnesses is a big problem, whether the case is with the jury or not. In our immigration cases, the immigration judges need to observe the person. If they don't have them there in the courtroom, then they don't have an opportunity to see their body language. They don't see how they're reacting with people who are watching. We have an open court system. That means that there are other people normally in the courtroom, and in an e-trial, usually there's not. We also have a constitutional requirement that we have people that people can observe, and we generally try to do that in an e-trial by making that open to the public. But we can't always do that. That violates the Constitution. Again, we need to know how do we handle this? Serious problem for us. Because remember that the Constitution is the ultimate law of the land, and it sets out the standards that must be followed. Supreme Court decides whether those standards are followed in a number of very important decisions here. And because we use a case law system where we follow precedent, what we've done in the past doesn't apply to the present. And that's, again, we're having to work through this. We don't really know how to deal with it. And this is part of the e-court system for us that we are struggling with. Here in Dallas, we have got a backlog of hundreds and hundreds of cases that we can't try. The problem with not being able to try a case is that you've got people staying in jail that don't need to be there, and we consider their freedom to be the most important right that they have. There needs to be a very good reason to take the freedom away from them, and if they're not guilty and they're sitting in jail languishing because they can't get a trial, it's ultimately extremely unfair, and yet we don't know yet how to be able to cut down this backlog and how to do trials and still not violate the Constitution. Now, this is different than in many of the other countries, but this is one that we must deal with, and we are trying to, but we don't have the answers yet. Now, I expect that the other issue that we have, often technical flaws, because of the number of different courts and the financial ability of many of them. They don't always have all the equipment that they need to be able to avoid having technical problems and the understanding of how to deal with those technical problems. Now, this is something that's becoming less and less of a problem, but it's been a huge problem in the past. We'll have a trial that's interrupted, and you can't, and when it is, then you don't know what happens with the people. Where do they go? Do they get information they shouldn't get? So in a criminal case, they then have to be excluded from the jury panel. And if they are, then you have to start the trial all over again. One more tremendous delay. So these issues, if you deal with the U.S. court system at all, you will feel them, you will see them. The federal courts tend to handle situations much better than the state courts, and certainly better than the local courts. The majority of people in this country in the criminal system are tried in the local courts. Simple things, traffic tickets. Even a traffic ticket, you have a right to a jury trial. So in some ways, it almost doesn't make sense, but you do. If the trial is demanded, they will get it. And if you don't, and if they can't get a jury, then that trial won't happen, and the case will never be decided. That's not fair to the rest of society. It's not fair to the prosecution, because you don't really have it's not the way the system's designed, and it shouldn't be. And yet we have it, and we don't quite know how to deal with that yet. So this is very much in its infancy for us. We know that that we need it, but it only works in some areas because of our constitutional limitations. I hope that's a little bit of a help in understanding our system. I want to mention that on the civil side, which is things involving money, usually, we still have the same issue, because we're entitled to a jury trial, and either of the attorneys, plaintiff or defendant, can request it, and they have to have it. The system works well when we have probate matters and we have things that can be decided by a judge, and you just need to have straightforward testimony from a number of witnesses. That we have worked out quite well, but not the situation where we have a contested trial and a jury has been demanded. I hope that's helpful.
That is Mr. Vincon. Thank you so much for shedding light on both the jury trial and the civil side of litigation in US. And with that, I take my attention to Dr. Kanu. Dr. Kanu, if you can also tell us some of the challenges and the solution that you are facing in the e-court system, and we'd like to also hear your thoughts as to how the world can unite and peacefully form a solution to the e-courts.
All right. Thank you very much. Good afternoon, good evening, good morning, depending on where you are. I'm communicating to us from Nigeria. I prepared a PowerPoint presentation. Would it be ideal to share, or you want me to speak orally?
I think we are good with either. If you can share your screen, I'm sure the participants would benefit. Unless there is an objection from the technical team, I think we are good to go.
Okay, I think they're saying the host disabled the participation screen scanning. So let me just go oral. But the PowerPoint I can send to the organizers after this discourse. Is that okay?
That is fine, Dr. Kanu.
Okay. All right, thank you. I am a PhD scholar. I'm yet to obtain my doctorate degree officially. Now, e-courts in Nigeria is very interesting discourse. I want to appreciate the management of the MIT World University of Peace for the privilege given to me to discuss on this topic. I'm not taking it for granted. Thank you very much for the opportunity. Now, for us to benefit maximally from this discourse, I believe we need to appreciate what is actually a court and what does court stand for. Do we see a court as a building where it is written the High Court of Judicature of the state of Hyderabad, or we see a court as service delivery system? So once we're able to understand and distinguish from these two, then we'll know whether or not there is the need for us to proceed to virtual court section now. Now, in summary, court is not just the physical house or building where the court is situated. It's far more than that. Court is a place where justice is delivered. Note the word "a place" in quotes, which means it can be anywhere. It mustn't be in a physical place. And that is what we have seen for the past 1 year plus. In the early 2020s, based on the outbreak of the COVID-19, virtually all the courtrooms everywhere in the world shut down, systems shut down, and people were suffering, litigants were suffering. There was no access to justice. People's rights were being violated, and what would society do? And that brought us to issue of virtual court sittings. India has gone far. Before now, there have been digitization of virtually all the courts in India, e-courts, system computers, everything have been equipped, of which I applaud the Indian judiciary, the E-Committee of the Indian Supreme Court. They have done noble work in this regard. And that fueled the success that the Indian judiciary experienced during the outbreak of the coronavirus pandemic, based on the issue of the virtual court sittings. Now, is it constitutional? Is virtual court sitting constitutional? Does the Constitution of India support virtual court sitting? That is the inevitable question we need to ask ourselves. But the truth of the matter is that the Constitution also makes provision, the Indian Constitution, which we can see in Article 145 of the Indian Constitution, made provision that the court sitting, judgment, decision should be delivered in public. And by necessary extension, where the issue lies is public. Can we say that virtual court sitting is a sitting in public? But if we wish to interpret it, we can actually say that provided that the members of the public, the litigants, the lawyers representing them, and members of the public have access through the link provided, that it meets the constitutional requirements. And that is the same thing that we have in Nigeria. Section 36, subsection 3 of the 1999 Constitution provides that a court sitting in Nigeria must be in public. Now, issues arose when the courtroom was also shut down in Nigeria. Many people said that the court cannot sit virtually. But eventually, certain cases went to the Supreme Court. Notably, we have the case of Attorney General of Lagos State against Attorney General of the Federation. It's a 2020 case. We also have Attorney General of Ekiti State against Attorney General of the Federation. It's a 2020 decision of the Supreme Court. In these two cases, the Supreme Court, so that leaves us with the answer that virtual court sitting in Nigeria and by extension in India is not unconstitutional. The truth of the matter is that the world has moved on. We cannot fold our arms and stand by and watch the world moving on. The judiciary have to act. We know before now the joy of going before a physical court to advocate, and you see people looking, admiring, and looking at your presentation, listening to your presentation, admiring the candor for which you are making your presentation. We know that the joy knows no bound. But be that as it may, they say necessity is the mother of invention. We are here faced with a pandemic that appears not to be giving way. Presently, we are having Omicron variant of the virus. We don't know what will come out next. So this is the new way to go, virtual court sitting, provided that access are given to litigants, provided that opportunities are given to the members of the public to register ahead of time in order to participate, it is legal. But however, there are challenges. We have several challenges both in Nigeria here and in India. The issue of internet, the unstable internet could also be a problem. When the judges are connecting, when attorneys are connecting, when litigants are connecting to a particular site, when the public are connected, there could be pressure. And at times you will tend to miss out one or two things due to poor network connection. Again, lack of computer literacy, especially in third world countries. So we find out that this is actually a setback. There are many shortcomings. Poverty. Most people don't even have money to buy computer system. They can't afford 3 square meals in a day. And these are the people you are talking about. They should, connect to judicial proceedings online. How? So also lack of adequate manpower. We need money to employ specialists that will take care of the system, to set up the website, to continually update the website with new cases, with new matters coming up. This requires money. There should also be the increase of ICT equipment distribution virtually in all the courts. In Nigeria, it was just last week that the first virtual criminal court was launched in Nigeria, in Abuja, the country's capital. So we have only one fully equipped facility where there could be virtual court sittings in Nigeria as we speak today. But the truth is that we are making progress. The state of Lagos are taking the bull by the horn. It was Lagos that delivered the first virtual judgment in Nigeria. Last year, precisely trying to get, precisely on 6th May 2020, Justice Mojisola Dada of the Lagos State High Court delivered a virtual court judgment wherein the defendant, Mr. Olaleko Hamid, was sentenced to death. This called for several hues and cry in the nation. People were questioning, how could someone be sentenced to death online? But the truth of the matter is that the defendant connected online from the prison custody, or the correctional center, as we call it now in Nigeria. The counsel also connected. The judge was in courtroom and delivered the judgment. So the essence of the virtual court sitting is not to go against the challenge of breaking the COVID-19 protocols, maintaining social distance so that every person can connect from wherever they are. So in summary, virtual court sitting, e-court is the norm. There are challenges, we know, but the most important thing, if the stakeholders in the justice system are willing, we can surmount the challenges. Thank you very much.
Thank you so much, Mr. Kanu, and I do hope you get your PhD very soon. Very well deserving lecture here we have all received, and I think the concept of justice that I think you have enunciated wonderfully is that a temple of justice may not be brick and mortar, but the concept that justice seems to be delivered in broad daylight to the people, I think that's a wonderful, wonderful notion. And with that, let me take the spotlight next to Dr. Thijani and pick his brain on these important issues of e-courts, the challenges and the solutions. Dr. Thijani, over to you.
So thank you very much. I wish to also thank you for the invitation to be part of this symposium on law and peace, International Symposium. Mr. Kanu has spoken a lot about the situation in Nigeria. I agree with him, especially with the challenges we face. But I want to point to certain areas where we have made some progress. Number one, alternative dispute resolution, arbitral proceedings. I am an arbitrator, and I know that we have leveraged on these parts of dispute resolution through that is that's virtual hearing, arbitral proceedings. So most of the institutions, arbitral institutions, they have leveraged on this. We don't have a jury system in Nigeria, just like, I don't know, just like Kenneth was discussing, where you need to have juries in place. But that is an area where we have made progress in the ADR, arbitral proceedings. Mr. Kanu has also mentioned some of the challenges we have, especially as it relates to manpower, the facilities to do these things. But what is noticeable in Nigeria is that there is a consensus that e-court is the way to go. We don't know when this COVID and the variants will end. So we now have practice directions by various courts stating that proceedings can be held virtually. Mr. Kanu referred to an authority by the Supreme Court. Other courts are now taking matters, especially on defended cases and applications. Motions are now taken virtually. So if you have a motion that is uncontested, even if it is contested, login details are sent to counsel and they log in. We have challenges of internet, like Mr. Kanu mentioned, but invariably, we have seen some progress in this respect. So we now have practice direction from the Court of Appeal, we have from the National Industrial Court, we have from the Federal High Court, encouraging counsel and the courts to do virtual hearing. But the part that I know as a fact from experience, a colleague of mine, he actually conducted a trial in a matrimonial cause virtually. He stayed in Lagos. The hearing was outside of Lagos, and he had good reports. So we are making progress in that area despite the challenges that we have. Now, we have not made too much progress to say that all states, we know that Nigeria is a federation. We have 36 states. So the level of progress in each state differ. In Lagos, they are usually at the forefront in Lagos because it's a commercial center and there is exposure to most of these facilities. But as we make progress, since there are understanding by all parties that virtual court hearing is the way to go, progress is being made in this respect. Like has been mentioned, you have skepticism by some who still insist on physical hearing. But even now in our courts, you can't, because of physical distancing, you don't have too many people in the courts. So when an opportunity arises for virtual hearing, counsel are usually willing to take on that. The way to go, in addition to what Mr. Kanu has said about the Nigerian situation, is to institutionalize virtual court hearing. What that means is that the Supreme Court has pronounced that is constitutional. It is now for the various layers of courts in their rules of courts to make it mandatory or make it optional, not optional, but a way to go. And I'm sure that counsel will take that into consideration. Infrastructural development, we are on that as long as we improve electricity, telecoms, that will also assist us. And then we have manpower development. Mr. Kanu has dealt on this. And funding too, which is required, especially for young practitioners. They need to be empowered, especially for funding, so that the necessary equipment for these hearings can be done. So this is our position in Nigeria is the way to go, and we are taking every step to see that virtual hearing is one that we incorporate in our administration of justice.
Thank you so much, Dr. Thijani. Just before I proceed further, let me quickly take the approval of the moderator, Dr. Bagchi. I'm under the impression that we have been given a time of 60 minutes to wrap up at 6:30. Can I take two quick questions with the panel?
Okay, please, fine. Go on, please.
Sir, I think even our Dean, Dr. Professor Anuradha Parasar ma'am, would agree that we can definitely take some more time and we can go ahead. Ma'am, I'm sure, I think we are not
we can.
bound
And,
by
actually, Advocate Jan, sure, please take those two questions, but our students are keenly waiting to raise the questions.
Sure. So two quick questions. Let me club them into one and go through the panel quickly so that the questions from the students can also be taken up. So let me club two questions together. I think wonderful points have been raised by the panelists. As a very close friend of mine told me when we are suffering from wave 1 and wave 2 of the pandemic and how we are in this COVID-19 situation, he said, "My friend, we are not in the same boat, we are in the same storm." And having heard the panelists, I think I cannot agree more, because be it US, be it Nigeria, be it Turkey, be it India, I think we are all facing similar problems in terms of our court infrastructure, the e-court challenges, and how to overcome them. So the second question, I think, which is very important for everybody, be it a litigant, be it the courts, is the question of privacy. When we think of attorney-client privilege or a lawyer-client privilege, privacy is of paramount nature. And with the e-court system, I think somewhere the questions have been starting to get raised. How do we go about securing this privacy, especially when everything is being filed online? Perhaps certain court systems may not have a robust system in terms of malware, spyware, or protect themselves from hacking. How do we go about that? Let me start with the panel one by one, and I would like Mr. Wincon to answer this first, and then I'll take the answers from other panelists.
This unmuted. Okay. Say now. What is the specific question again?
Yes, Mr. Wincon, the question is in the scenario of e-courts, the attorney-client privilege and the issue of privacy, I think, takes paramount importance, especially given the scenario that most of the filing and the hearing is being done online. What, in your opinion, is the best thing or the best practices that one can embrace to ensure that the attorney-client privilege is maintained and the privacy of the client is not thrown to the winds?
The privacy of the client is absolutely critical, and well, it's a very difficult question to answer. Actually, I'm just thinking that privacy in these proceedings is difficult. We have in the United States, we have many of the courts that simply don't hold, just don't even hold tribunals at all. They don't hold trials. We have some of the judges who are recalcitrant, who just refuse to come into the modern age that they have to. I don't know the answer to it. The e-court system it's really difficult in this country because of the requirements that we have, the constitutional requirements. If I'm understanding what you're asking, I did want to mention that one of the main advantages of this system is that travel is so much easier. We can have people testify where otherwise we couldn't. So that's a huge advantage. But it doesn't help any if we can't hold a trial. We can get statements from people. We can record their statements, but ultimately, with if the trial never happens, we're really the whole process is defeated. The purpose of the process. I don't know if that answers your question, but maybe you can state it a little differently if it'll help.
Sure. Thank you, Mr. Wincon. I think that to some extent does explain the conundrum with the courts and with the lawyers. Let me now take this question also to Dr. Thijani, and if he can shed some light on this.
Well, from the Nigerian perspective, this is a developing area. The stage we are now mostly is to upload the originating process, the writ of summons or the papers that are filed, they are uploaded to the server. You can track the courts. Other than that, fewer documents are on the website. The website of the Supreme Court has judgments delivered, but now there are directions that your briefs should also be uploaded. So you can actually trace that. But because the level of IT exposure, there are moves to protect the client's the privacy, but we may not be there because as these things develop, as the challenges emanate, we'll be able to find ways. But there are things that are being done now, but not tested as to whether it will breach the privacy of the clients. Because the level we are now, we are not so, it's not so automated as to put everything online. What you can get online are public documents like the originating processes, which you can always apply to have. So the position we have now is that some of these documents are there. There are attempts to ensure privacy, but we have not had situations of a breach of those privacy, and we have not had a situation where we to be tested how we are going to combat that. But that is something that is always at the forefront. Both the lawyers and the clients, they're always having those thoughts that if my documents are in the air, they are exposed. What about the privacy, especially for commercial disputes?
Very wonderfully explained, Dr. Thijani. Thank you for that answer. Let me take the limelight to Dr. Fojlali. If you can share your opinion with us on this issue. Dr. Fojlali, can you hear us? I think perhaps his connection may have been lost. Let me just move on to Mr. Kanu and take his opinion on this.
All right, thank you very much for the opportunity again. I appreciate. Now, where parties have decided to submit their matters to litigation, their privacy is greatly eroded because inevitably the case will be decided and there will be law reports of the decision. So it means that the matter is already in the public domain. Just as our people say, there's an adage here that a woman who gave birth in a marketplace, there is no need for her to hide anything again. That is already in the public domain. So parties that have submitted their matter to the court, they have willingly also given up their privacy. When you're talking about privacy, attorney-client privacy is not as a regard to matters that have been filed in the court. In the courtroom, whether it is the physical courtroom or the virtual courtroom, there are provisions made for public to witness the proceedings. So there is no privacy there again. The proceedings will be reported by pressmen. What privacy are we talking about? We have a case in Nigeria, a case Menakaya against Menakaya. It was decided years back, where it was held that proceedings held in camera, they are unconstitutional. So proceedings must be held in public. Section 36, subsection 3 of the 1999 Constitution is instructive on this. We also have Article 145, subsection 4 of the Indian Constitution is also instructive on this matter, that proceedings must be held in public. So, that notwithstanding, we also know there is the issue of fear of the website being hacked in order to corrupt materials. But that does not actually relate to issue of privacy to a large extent, because just as I have said, matter submitted in court is deemed to be in the public domain. The court is not a private place as such. Litigants have access to the courtroom. They have access to requests for documents. We have Freedom of Information Act in Nigeria now. If you require certain information, you are entitled to have it, except information that are maybe classified as security informations, which you need clearance from the security agencies before you have access to those information. But what we are saying is the issue of privacy as it relates to e-trial, litigants are not actually, to worry about that. Because even in the physical courtroom, you are in the public domain. People see you. People hear about the case. So what are you talking about? Privacy. Thank you very much.
Thank you. Thank you so much, Mr. Kanu, for sharing your thoughts with us. And in a lighter vein, let me quickly put the last question before we start taking the questions from the student panel, is about the decorum in the court, especially the e-courts. We have seen the judges getting annoyed, so much so that in certain cases, at least in Indian courts, contempt was issued, because we have seen certain litigants or even lawyers appearing in bathrobes, half naked, or in transit, or eating, perhaps a few lawyers also smoking on the screen while the hearing was going on, creating great displeasure to the judges and to the legal fraternity. So I would quickly like to pick your brain on this, and let me start quickly with Mr. Wincon and his thoughts on the contempt of court, especially when people are ill-dressed.
Say that again, please.
Mr. Wincon, the question is, what is your take on people not dressing properly, be it the litigants or the lawyers? Sometimes it was seen that people appeared in bathrobe or in a semi-naked attire before the court, sometimes eating or drinking or even smoking. The world over, there have been incidents which have been captured in the last 2 years of pandemic. So your thoughts on the same, sir?
That's certainly a problem. We actually had one lawyer who was caught doing something even worse on television, and he lost his job as a commentator on a very important commentator, and he was at the time quite a powerful individual with one of the law schools. You have to be awfully careful as to what's shown on the screen, and from a lawyer's standpoint, we have very little control over that, other than to advise our clients very carefully to remember that there's certain things you don't do. This is one of the problems also that I was trying to mention earlier, that the demeanor of each witness is critical in deciding the case, and it's not always apparent on a screen. However, if someone makes a mistake because they think that it's private, they think that they're not on, they are, it can absolutely be devastating. So the only way to avoid that kind of an issue, I think, is just to carefully counsel your client, and also for the lawyer himself to be careful. It's so easy to forget that you're on a video, and forget to turn it off when you're going to go and have a conference with a client. That's been a problem quite often. The privacy is gone if that happens, and you can sometimes put your client in a terrible position if you make a statement when you shouldn't, thinking that the sound is off.
That's wonderful, insight into the predicament of practicing, in a court, especially in virtual courts. Sometimes, just out of our, not being aware of the camera being on or the mic being on, we may utter something which may put disgrace to the whole system. Let me also then quickly move to Dr. Thijani and take his opinion on this aspect.
If I could make one more comment.
Sure, please.
The privacy, the issue of a public forum, being able to know everything is different, I think, in the United States than in most other countries. we have a series of rules to protect individuals from revealing information that is either embarrassing but not related to the trial. Especially true in sex crime cases, trying to protect a witness, a child. The public is not entitled to all the knowledge of this, and you normally file a motion in limine to eliminate this testimony. If you know about it beforehand, the prosecution does it, or in some cases the defense might do it. But the public is not entitled to everything. There are certain things which have nothing to do with the trial, that don't add to reaching a just conclusion. And we don't want to have those just thrown out in the public and to destroy people's lives.
Point taken. Thank you. Thank you so much, Mr. Vincon, for that illustration. Over to you, Dr. Thijani.
So thank you very much. This is an area where we have made a lot of progress in Nigeria. I have before me here the Court of Appeal Rules 2021 is the new rules. Order 21 of the Court of Appeal Rules. In fact, Order 20 deals with electronic filing. Order 21, I just want to read a few of the rules of that order to show that this has been contemplated, the mode of dressing and all of that. Order 21, Rule 1 says the court may conduct its proceedings virtually where it deems fit. Then Rule 2, virtual hearings shall be by means of any audiovisual platform approved by the court, and a link will be provided to enable the public to observe the virtual proceedings. That is Rule 2. Rule 3, where the court adopts virtual hearing for any proceedings in an appeal, the registrar shall notify the parties. Now, listen to this Rule 4. The justices of the Court of Appeal and counsel appearing in the appeal shall be fully robed for the virtual hearing. So the point that is being made here is that the Court of Appeal Rules 2021 in Nigeria has already taken care of this situation. I agree with you that some were dressing shabbily with a red shirt without a tie. Some of them would not switch on their cameras. But the rules now make it mandatory as if it is a court fully robed. Now look at Rule 5. It says all rules and practices on decorum and etiquette during physical hearing shall be observed by counsel and parties during virtual hearing. So it is now regulated. So we have a regulated system, and most of the other courts are going to adopt this because this is by the Court of Appeal. So virtual hearings are regulated. Dressing, etiquette, and decorum, they are regulated in our procedure now.
Thank you. Thank you so much, Dr. Thijani, and the wonderful steps taken by the institutions there. Over to you, Mr. Kanu. Your thoughts on this issue?
All right. Thank you very much. In addition to what my boss has said, Dr. Thijani, we have made progress on this area in Nigeria. Now, we need to understand that court proceedings, they are not tea party. It's not something that should be taken just as a matter of course. It's something you have to prepare. It's a mindset something. If the attorney sees it as a regular court proceedings, I do not see the reason why the attorney will not be properly robed, irrespective of the fact that he's appearing from his chambers. Again, practice directions in support of the court rules have also taken care of this aspect. And also, I should recommend also that the MBA, the bar associations of each state, should also take it up to educate members on how to behave, on the decorum and demeanor they are supposed to adopt when appearing virtually. Also, the rules of professional conduct for legal practitioners in Nigeria makes provision on how legal practitioners are supposed to appear before any court. So there is no exception that where you are appearing online, you are supposed to put on your boxers only because you are not appearing in a physical court. No, there is no such exception. In fact, as a practitioner, you should be an example, epitome of example for your clients, which means you are supposed to educate your clients on the requirements of appearing virtually, because demeanor is very important. Just as our senior colleague from Texas has said, the court observing your demeanor. You may behave in such a way that you will infuriate the court, will not show it up, but when discretion, certain discretions are to be made in your favor, it will be refused because of your behavior towards the court. So generally, the legal profession should enact rules. In Nigeria, we have it. I don't know about India for now and other jurisdictions, but I know that the rules of professional conduct forbids lawyers from appearing before the court shabbily. Thank you very much.
Thank you. Thank you so much, Mr. Kanu. And just to say that in India, we have Advocates Act, which prescribes decence, decorum, and attire for an attorney to be appearing before the court. And with this note, I must encourage all the lawyers and the young lawyers to be that please always prepare your brief and don't appear briefless before the court to maintain the court's decorum. I think that is very, very important, and the message that we take away from today's session. Over to you, Dr. Bakchi. I think my questions and answers have been wonderfully answered by the panel here. And over to you, and thank you again for having all of us on this panel today.
Thank you so much, Advocate Jen. But we indeed enjoyed this deliberation. And honestly speaking, I think we are eagerly waiting to have some more questions answered, especially from our students. Our student panel is waiting to ask a few questions to the panel, and with the permission of the chair, I would like to take the names of few students who have volunteered to ask questions to our dignitaries. So I would first request Mr. Kabir from School of Law at MIT World Peace University to kindly unmute himself and ask the first question. Kabir, over to you.
Greetings to everyone. My question is for the moderator, Advocate Bhatt. So the question is, how do we overcome the flaws holding us back from making it possible to permit all types of cases in e-courts?
I think the panel has already shed some light. Let me quickly encapsulate it, because the two type of broad category of cases is one that you conduct in trial and one that you conduct in appeals. So the problem in conducting trials, especially given the Indian scenario, is the last mile availability of technology. And that is also something that Mr. Kanu and Dr. Thijani also shared with respect to Nigeria. I think the problem with the trials is that if you conduct it online, and if the courtroom is absent here, or a proper government officer or a judicial officer who can supervise a proper trial, there may be chances in either tempering of the witness or tutoring a witness, and there can be certain problems in terms of conducting a proper examination in chief or cross-examination, especially during the criminal trials. Even civil or commercial trials may fall in the same domain. Similar type of problem is also being witnessed in the area of alternate dispute resolution, or as we call them ADR, be it arbitration, be it mediation, or be it conciliation, especially in the matrimonial matters, where parties could have physically sat in a room, could have read each other's body language, perhaps could have spoken to one-on-one directly, sometimes in the absence of their lawyer colleagues. Things are very different when you're appearing virtually. The tempers may be running high, there may be a lot of animosity or bad blood between the parties appearing virtually, and some sort of misunderstanding may also happen. And to add to that, the woes of a bad technology or a bad connection, which may add to a smooth functioning of any court. So I think we still have a very long way to go, but I think the Indian Supreme Court has made a drastic move last year during the first lockdown that happened in the country, and thereafter how the high courts and other tribunals and our district courts have adopted the virtual system, I think has been wonderfully done. But we still need to think whether going forward in terms of e-courts and the eventuality of justice delivery system. Should we go for a hybrid model? Should e-courts be the way forward in the future? Or should we go back to physical courts now that they are resuming normalcy in the country? I think for that we'll have to wait for next 2 to 4 years to first decide as and when Corona is behind us, and second, how quickly our judicial system, and not just our judicial system, I think the judicial system across the globe adapts to the changing scenario.
Right. Thank you so much, sir. And I'm sure in our next editions of ISLP, the hybrid model will very much be in discussion and deliberation. Thank you so much, Kabir. I would now request Mr. Rutvik Sapkal from School of Law at MIT World Peace University to kindly ask the next question to our panel. Rutvik, over to you.
Thank you, ma'am. Greetings to everyone from MIT School of Law. My question is to Advocate Kenneth Lincoln, sir. So my question is, how do we ensure privacy when it comes to medical reports, psychological evaluations that are introduced during trials?
Well, Rutvik, I would request you to repeat the question. Kanu, sir?
Yes.
Yeah, Kanu, sir, the question is to you.
Ma'am, it's for Advocate Kenneth Lincoln.
I'll request Kanu, sir, to answer this question. Yes, Mr. Kanu, the question is for you. Rutvik, I'll request you to please repeat the question once.
Yes, ma'am. So, sir, my question is, how do we ensure privacy when it comes to medical reports, psychological evaluations that are introduced during trials?
Mr. Kanu, I'll request you to unmute yourself. I think you're speaking, but I think you're still on mute. I'll request you to just unmute yourself. If you can kindly unmute your microphone.
Hello, can you hear me?
Yes, sir, you're audible.
Okay. Please, may I get the question again, please?
Yes, sir. The question is, how do we maintain the privacy of the reports, especially the medical reports, the psychological reports that are submitted in the courts for review?
How do we do what?
Maintain the privacy of reports, the medical reports that are submitted for review in the courts. Even the psychological reports for that matter, sir.
All right. Now, these reports, let's picture a usual court setting. When you file your matters in court, you file together with all the pieces of evidence you want to rely upon. And during proceedings, these documents are tendered in court. You show it to the other party. And if there is need for objection, objections are taken and it is ruled upon by the court. Now, eventually the matter is decided one way or the other. These material evidence, documents that you have submitted, irrespective of what they are called, they have become available to members of the public. And if members of the public want to access them, they are entitled to access these documents. We have seen counsel who could apply for record of proceedings and for certified true copies of every document in the court file. This will be made available to them. So the issue of maintenance of privacy at that particular stage has become limited to a great extent. So you find out that your right to privacy is limited once you have submitted your matter to litigation before the court of law. Thank you very much.
Thank you so much, sir, in fact, for shedding a very important insight and shedding light on the right to privacy and how it gets limited once the submission is done for a trial. And thank you so much, Rutvik, for that question. I'll now request Mr. Sumed Patil from School of Law at MIT World Peace University to kindly ask the next question. Sumed, over to you.
Thank you, ma'am. Am I audible?
Yes, you are.
Yeah. So my question is to Dr. Thijani. So as we know that the courts are trying to adapt the use of technology in handling the court cases, I'd just like to ask you, how do you think we can overcome the lack of techno-legal expertise?
Well, thank you very much for the question. It's a deliberate step manpower development, training. I don't know the situation well in India, but I know that over here, most people are not trained. They don't have this proficiency in the use of the computers or the internet. So manpower development is important. It's also important for the judges. It's not only for the lawyers. So, you know, there are the two of them that both the lawyers and the judges, the bench and the bar, they must be trained manpower development so that they feel more comfortable. You know, the younger ones now, we feel more comfortable on the net because we can upload materials. Some of us even read e-books more than the physical books. But the judges that we have, they would rather see it physical before they can enjoy it. So this will require orientation, manpower development, a lot of training, and we'll get around this.
Thank you. Thank you so much.
May I add something a bit there?
Sure, sure, Mr. Kanu. Please go ahead.
We also have to note that in terms of training, I think India have done very well in terms of equipped manpower training. Between May 2020 and June 2021, the E-Committee of the Supreme Court of India have conducted about 30 trainings for judicial officers of both national and the state level. So it's something that they are on it. And I give India kudos for this giant strides. Thank you.
Thank you. Thank you so much. In fact, a matter of pride for all of us, where we really must acknowledge the kind of trainings that, of course, Bharat has done for all the professionals in this field. Thank you so much, Mr. Kanu, and thank you so much, Dr. Thijani, for answering that question so well. And thanks, Sumit, for that question. I would now like to request Ms. Mansi Gala from School of Law at MIT World Peace University to kindly ask the next question. Mansi, over to you.
Thank you, ma'am. Good evening to all the dignitaries. My question is to Kanu, sir. How can maintenance of decorum and court mannerisms be ensured?
All right. Can I go on?
Yeah, yes, sir, please.
Okay. Maintenance of decorum. I think a lot have to be said about self-discipline. Self-discipline is the key. There is what we call common sense. A practitioner, an attorney, knows that a court section is an absolute business. It is not a tea party, as I've said before, which means you must be tuned to it, both mentally and you are physically prepared for this court section. Assume that you are appearing before a physical court. Do not assume that you are appearing virtually from your law firm or from home. So set up, have that mindset, that mentality, that I am an attorney representing a client, whether criminal case or civil case. Under the liberty of this person, I have the responsibility to represent it in accordance with the provisions of the law. So once you have this mindset as an attorney, whether you're a junior counsel or you're a senior counsel, you should be able to know that there are certain things the society expects from you part-time, and you are not supposed to let your guard down. So the rules of professional conduct are there to regulate our conduct, how we should behave before we are appearing before any court, how we are supposed to be attired, how you are supposed to talk, how you are supposed to address the court, so that the court will feel dignified part-time. So these things are taught in the university. Now, in the law school where we are, I'm a lecturer at the Nigerian Law School, a senior lecturer, and my boss is here with us. We try to inculcate this discipline to students. We have moot court sections. where we teach them the normal court practices, how they are supposed to behave, how they are supposed to talk, and how they are supposed to be attired, prepare their cases before they come to court. So these things comes with training. And I believe that India have done so well in terms of also training lawyers. So the rules of professional conduct are there, and self-discipline, particularly to the attorney or to the advocate, is key, because irrespective of whatever you are taught in the law school or in the university, if you as a person decides to overlook them, there is nothing anybody can do. The only thing we can do is that we sanction you for misbehaving and we'll take away your license. Thank you very much.
Thank you. Thank you so much, Kanu sir. In fact, indeed, as you rightly said, it all begins with the mindset, and the training very much comes from the moot court sessions. And let me quickly mention that at MITW School of Law, we indeed enjoy the moot court sessions with our students, where their trainings and the formal trainings encourage them to follow the professional code of conduct. So thank you so much, Mansi, for that question. And the last question from the student volunteers for the day, I request Ms. Janvi Singh from School of Law at MIT World Peace University to kindly ask the next question. Janvi, over to you.
Am I audible?
Yes, Janvi, please ask your question.
Okay, greetings to one and all. My question is to Mr. Wincott. Like e-courts permits only certain types of cases. So will it be possible for e-courts to permit all kinds or sorts of cases?
The question is to Mr. Kenneth Vinton, and I request Janvi to please repeat the question by holding the mic close so that you are clearly audible to Mr. Wincott. Janvi, can you say it loudly once again?
Okay.
Yes.
E-courts permits only certain types of cases. Will it be possible for e-courts to permit all the types of cases?
I request Mr. Kenneth Wincott to kindly unmute himself and answer the question.
Yes. The e-courts are not going to be able to handle all types of issues at this time. There are certain things which are just not amenable to being decided by the e-courts, but in public session, the judges will make decisions. We'll be filing our documents, doing the e-filings. The judges can make rulings. And that's easily done in the e-court setting. Actually, that's one of the best use of e-courts. In our system, it works quite well. The trials, which are judge trials, for instance, here, probate matters, some family court matters can be done in e-courts and work quite well. But all matters don't resolve themselves very well with e-courts, and that comes mainly in our system in the criminal context because of our Constitution that I mentioned earlier. That really causes a big problem if there's a demand for a jury trial and you can't always get a jury, and second, in some locations they really don't understand the e-court system. Now that's rare in the United States. You get into some rural districts, some of the states that are not quite as advanced as others, but in general, the trials which are done to a judge can be done much more easily than those which require a jury. I hope that helped.
That very much helps. Thank you. Thank you so much, Mr. Whitwood, for carefully answering this question. And thank you, Janvi, for asking that question. Thanks to all the student coordinators from School of Law at MIT World Peace University for volunteering to ask questions to our distinguished panel. And thank you so much to all the dignitaries as well as the moderator for conducting such an important deliberation on this topic of e-courts, the future. And with this, I would now like to request my technical team to kindly share the resolution of session 1 of the first ISLP, Dear participants, we are about to witness the first polling on the resolution of session 1, E-Courts the Future. You have exactly 1 minute. You will be given a link to cast your vote for or against the motion. I will read out the resolution for you all, and I request all the participants to please cast their valuable vote within a minute. After a minute, the polling ends and we'll have the results displayed. We, the participants of First International Symposium on Law and Peace, hereby request the union and state governments to facilitate setting up of the virtual courts, which is the way forward for the hassle-free, time-bound, and effective delivery of justice to the citizens of the country, wherein there would be no requirement to visit a court in person. And indeed, this is one of the most effective resolutions that we will be passing from the very first International Symposium on Law and Peace. Well, I think the poll option is visible to all the participants. I'll again request you all to kindly cast your valuable vote for or against the motion. And shortly, maybe in a matter of a few seconds, we'll have the results of the poll displayed to you all, where we can see that how many people have actually voted for the motion and have felt the cause of the E-Courts being the major part of the whole system and mechanism of the judiciary. That's excellent. We have 76% of the participants voting for the motion. And thank you so much. Let us have a huge round of applause for the wholehearted participation of all the members and all the delegates. First, in the first session of ISLP. Thank you so much. And as we move towards the closure, I would kindly request Professor K. Girisan, the Director of School of Government of MIT World Peace University, to kindly give the concluding remarks as well as propose the vote of thanks for this session. Sir, over to you.
Thank you. Namaste. Good evening, good afternoon, good morning, as per the time zone of the delegates. As a person from the non-legal background, I must say that I have thoroughly enjoyed the presentations and deliberations of the session, E-Courts the Future. And as a student of public administration, to me, E-Courts have been able to enhance judicial productivity and also make the justice delivery system more accessible, cost-effective, reliable, and transparent from the citizen's perspective. But today's sessions convinced me that though these judicial reforms have been citizen-centric and citizen-friendly from a perspective, but there are several operational limitations which cannot be ignored, especially in third world countries, like many countries. I think the presentations from the Nigeria have been real examples. And significantly, COVID-19 crisis have served as a catalyst to the digitization of justice and court administration. I'm sure the trend for systematic and scientific approach to technology integration in judiciary will only be strengthened in the months and years ahead. At the same time, the concerns and issues of connectivity and illiteracy and network connectivity, all these things need to be seriously taken into account. Also, the questions of privacy and other issues highlighted by the moderator as well as the speakers. Presentations of the guest speakers were primarily revolved around the challenges and solutions of E-Courts as initially flagged by the moderator, Advocate Jayant Bhatt. And the comments made by the moderator, we are not in the same boat, but we are in the same storm, I think sums up the gist of the whole session. And the session has been very much informative and lively. And we had very fruitful and detailed deliberations with certain sharp questions from the moderator on issues of privacy and decorum in the E-Court. And of course, the responses from the guest speakers were equally good. It opened up a lot of understanding to all of us, especially the budding law graduates of MIT World Peace University. And there were some interesting questions raised by the students as well. I'm sure this is a great opportunity for them to listen to such kind of galaxy of legal luminaries from across the world. And it was well explained by the moderator and other speakers. And on behalf of Dr. Vishwanath Karat, MIT World Peace University, the founder and the executive president, Sri Rahul Karat, and the members of the organizing committee, I wish to place on record our deep sense of appreciation and gratitude to the moderator for excellently moderating the session, Sri Advocate Jain Bhatt. And also the guest speakers, Dr. Mehrat, Kenneth Wincombe, Charles Kanu, and Dr. Naziru for their fantastic presentations and detailed deliberations and patiently answering to the questions from the students as well as the moderator. And I wish to place on record gratitude to Professor Anuradha Parasar and her team for conceiving an international symposium and also excellent team of eCodes the future. And my thanks to Professor Bharat Chaudhary who welcomed the gathering, and also to Dr. Pranima Bagchi for excellent comparing. And once again, thanks to all participants, and very importantly, a word of gratitude to the moderator as well as the guest speakers. Thank you.
And thank you so much, Professor Girisan, for indeed concluding the session on such a positive note. And I must say that we have indeed witnessed one of the most important deliberations. By the way, dear participants, this is just the start. This is just the beginning. We have come towards the conclusion of session 1 of the first International Symposium on Law and Peace. But before formally bidding goodbye, I would like to make a very important announcement for tomorrow. That is day 2 of the first ISLP comprises a plethora of deliberations. And let me quickly cover the sessions that we'll have tomorrow. So at 2 p.m. IST, we have session 2, which is on DNA profiling, the way forward. Then the next session, that is session 3 of ISLP, begins at 4:30 IST, which is on the theme Changing Dimensions of Competition Law or Antitrust Law. And finally, tomorrow we have a very important session at 7 p.m. IST, which is the Youth to Youth Connect on another important theme, unlocking fake news by regulation. Here our student volunteers and student representatives across the globe will come together and have an interesting discussion. So thank you so much to all the delegates, all the participants, and on behalf of Dr. Vishwanath Karat, MIT World Peace University, I, Dr. Pranima Bagchi from School of Law at MIT World Peace University, would like to conclude the session with the permission of the chair. Thank you once again. Take care, stay safe, and see you tomorrow for session 2 at 2 p.m. sharp.